This Honorable Court of Tennessee is now in session.
Thank you. The Tennessee Court of Criminal Appeals is meeting in its March term for the Western section. And on the panel today, to my right, Judge Tim Easter from Williamson County, and to my left, Judge Ross Dyer from Shelby County. You may call our case, please.
State of Tennessee versus Mannan, Mehdi.
Thank you. Arguments are 20 minutes aside. If the appellant wishes to reserve a portion of that time for rebuttal, announce that at the beginning of your argument. All right, Mr. Wharton, you may proceed.
Yes, sir, Your Honor. Thank you. Good afternoon, Judge Witt, Judge Easter, Judge Dyer. Good afternoon to all of you, Honors. I would like, Your Honor, to begin by asking the court permission to reserve 5 minutes for rebuttal this afternoon. Honors, may it please the court, it is a pleasure to be here on behalf of my client this afternoon, Mr. Mannan, Mehdi. Your Honor, by way of introduction, this matter proceeded to court via guilty plea. Mr. Mannan, Mehdi entered a guilty plea to a Class E felony of sexual battery. Your Honor, for purposes of today, via, I guess, if you will, a roadmap, I think there are really three issues that are front and center for the court's consideration this afternoon in this case. And although this is a divergent case, Your Honor, I think it's significant in a number of respects, but primarily the three arguments that I would like to address for purposes of oral argument are as follows. Number one, that is, did the court, by its actions, grant or deny Mr. Mehdi the right to have a fair and full hearing? I have phrased that in our brief somewhat differently, but I think that's at the core of what we're arguing, and that is the right to due process, fundamentally fair and complete hearing. Number two, Your Honors, was there a failure to consider the appropriate factors, first of all, under the Sentencing Act of the State of Tennessee, then more importantly, to weigh those factors appropriately? Number three, Your Honors, whether the categorical comments regarding the particular charge at issue, that is sexual battery, rendered this court incapable of reaching and I apologize, Your Honor, reaching a fair and impartial decision based on the court comments made in the course of it. So for my minutes I have with you all this afternoon, Your Honors, those are the issues that I would like to address.
Warden, you have not amended your brief from November the 23rd, have you? Is that the brief we're looking at?
That is the brief that we're relying on for purposes of. Yes,
the single issue I see is whether the trial court abused its discretion by giving weight and relevant factors to considering improper factors when denying requests for diversion. So it's a denial of diversion.
That's the issue. And yes, sir, Judge. And so I guess I need to qualify the roadmap I just provided to the court. These are the way I phrase and categorize my arguments for today, but we're standing on until and if I request leave from this court to submit any additional case law, we're standing on what is contained in the brief, the authorities that we've cited, and the arguments raised. But the way I categorize or phrase for purposes of oral argument, what we're dealing with here, it would be how I've said before. But I think those are consistent with what I've raised in front of Your Honors in terms of the issue.
Okay.
Your Honor, to begin with, I do want to point out there are a number of cases. I mean, we cited several of them in our brief, and I'm not going to go and regurgitate what's in the brief. But there are a number of cases this court has not been hesitant to reverse a trial court in a scenario such as this. State versus White was a case out of Jackson where this court, and I believe Judge Dyer and Judge Easter, you all were on that panel. That case came out in 2018. State versus Frazier, that was another case out of Jackson, 2007. that was reversed for similar. Judge Witt, you presided on that panel. I'm not going to go through the case law. I think the issues are pretty succinct, and I'm going to deal with them in turn. To begin with, Your Honors, the court in various iterations, this court, as I indicated, has not been hesitant under certain circumstances to reverse where certain dictates of our state law and our case law and our statutory law not been followed by the trial court, or in some instances, the district attorney's office. And as the court is, this court is well aware, the law seems to be the same in terms of the review of an attorney general pretrial diversion decision as well as judicial diversion. What we have in this case, Your Honor, essentially is this. The hearing started out where Mr. Mehdi was testifying on direct examination after he had entered his guilty plea, and we were putting forth a petition for diversion. Mr. Mehdi attempted to give his background, his social history, his characteristics. He started talking about his employment and some of those things. It was at that point, and this is from the record, it was at that point that the court set forth the information that she wanted us to be concerned with in the scope and course of our petition. And those were essentially three things. And I'm paraphrasing those. In essence, what she said was, I want to hear whether or not Mr. Mehdi did it. First of all, did it happen? Is he sorry? And will it happen again? That was the scope under which the court said she wanted to have the hearing go. And that was the direction where the court said the hearing should go. At that point, Your Honor, I attempted very shortly after that to ask Mr. Mehdi some context about his family, his employment, his other circumstances. And I think at that very point, the court reiterated, no, I don't need the background. I've told you what I needed to hear. So therein lies this first issue that I'm talking about in terms of the full and fair hearing. But it also, Judge Easter, to your question earlier, goes to whether or not the court considered all of the factors under the law dealing with diversion, under the law as it relates to the Tennessee Code annotated.
Mr. Wharton, let me ask you a question. Not to short circuit your argument here, because I do want to hear all of it. But when you look at the first kind of outline you've got there, you didn't get a full and fair hearing. What do we have any choice, if we agree with you, but to send it back? Because I wrote down as I was reading your brief, you have a quote in there that the record was not fully developed. Well, if the record's not fully developed, our only conclusion, if we agree with you, is to send it back. Would it not be? We couldn't impose diversion if we don't have a full record, do we?
I think under the circumstances, Judge Dyer, that existed in this record, based on the record not being complete, and how the court limited the scope of what she was going to review and pretty much told us that, I think it'd be very difficult under the case law that I've read and some of the opinions you've written, Judge Dyer, for this court to then engage in its own, if you will, Tuesday afternoon quarterbacking to then make a call in terms of what the court should have heard. Because at that point, you don't have a complete record. So I think it'd be very difficult. And I think the case law by this court frowns upon that when the record is just incomplete. So
then if we agree with you, we would need to make, in your opinion, we need to make our opinion very clear as to what needs to be considered and how it needs to play out at the trial level in order to avoid, because you're kind of one of your later claims is the judge just has a preconceived idea against this type of crime.
Well, I'm sorry, Your Honor, you finished.
No, I mean, so do you see what I'm saying? I mean, we're going to have to send it back very specifically if we agree with you. Is how I'm kind of reading all this. Yeah,
and that goes to one of the other points, Your Honor, really in point 3, where I'm dealing with this issue of the categorical, and I wouldn't touch on that now. I think if the court does agree with us as the appellant, and if the case is remanded, one of the big questions is whether this court, with all due respect to this court, in the trial court, I should say, whether the trial court, because of the comments that have been made, can preside over this hearing. No matter how complete it is when it comes back, is there this predisposition, if you will, to these kinds of cases? I mean, I think the comments were fairly clear about sex cases, whether it's man, woman, man, woman. The court has given an indication, and repeatedly, Your Honor, and we've cited some of the cases, but I found 3 or 4 more in preparing for this afternoon. This court has frowned upon the trial courts engaging in legislating, if you will, to say, look, I just don't believe in this. You're taking away my discretion. Well, the legislature set forth certain crimes that are ineligible. And if it is not set forth expressly crimes that are ineligible, certain crimes are eligible, and you ought to consider the factors. And that's not to be a governing factor. So to answer your question, Judge Dyer, I think the issue is, yes, if it comes back, my relief that we're requesting on behalf of Mr. Mehdi would be that it go before a different judge. Just because of, in order to afford him the appearance of impartiality, and to, you almost have to start from scratch. Because we don't know how complete the hearing would have been, and we don't know what portion or what weight was attributed to this being a categorically frowned upon case by this judge, or whether or not that was a small fact. It appeared to be great if you look at some of the language. But yeah, I would think the instructions need to be clear on remand, but I don't think they necessarily need to be as clear if it goes before a different judge. The judge, or whatever trial court ends up getting, and needs to just follow the law and give a full and complete hearing.
Thank you.
So, Your Honors, and just going back through, there were a number of concerns. Obviously, one of the things that the court had to consider, and it seemed like, this is not conceding our first point, whether or not the court considered all of the relevant factors, or whether this court can make any determination on what weight was applied. So I don't think there's any presumption here at all. And I don't think the court can even speculate how much weight was given to one versus the other. I do know what is being made clear from this record is that there is a predisposition to sex crimes, no matter the gender, as compared to things like a property crime, because that's language actually from the opinion. And so if you look at the nature of this offense, to the extent the court does engage in trying to determine on this record whether there's any basis to sustain or affirm this verdict, even if you look at the nature of the offense itself, there is nothing in this particular record, and I think the case law talks about whether there's something extraordinary about the facts of the case that would allow the court to maybe independently make an assessment. We don't think those are here, and we don't think the necessary factors have been laid out for purpose of the record to determine this was some extraordinary case. I think that's the language that the courts, the judges, appellate judges use. We don't think the record would support that. Your Honor, at the end of the day, we know Mr. Mehdi had no record. I think the state has conceded that he was an eligible candidate. He had some other issues related to his social situation with his family, separated from his family as a young child. The court talked about, I think, his child and wanting to potentially maybe prevent something happening. There was no suggestion that that his child had ever. I mean, so a lot of this was, in my opinion, Your Honor, in my argument I'm making respectfully, really centered on this whole notion of the nature of the crime in general. I think the court, in trying to justify that, made those statements. Your Honors, in summary, our position is clear on this issue. We believe the court did not engage in the appropriate analysis in terms of the factors that are supposed to be considered for diversion, whether it be the case law under the Parker and electroplating, whether it be the statute under Title 40, 35, then also facts that were afforded here did not afford Mr. Mehdi an opportunity to put on a full and fair hearing. And because he was denied the dictates of our state law and our case law, he was denied an opportunity to have a court for the appropriate purpose. There was no full and fair hearing. This judge, this trial court, in considering diversion, was necessarily and respectfully, in my opinion, had a predisposition that's been frowned upon by this court. We're asking the court, I know I'm probably just before my time, but we're asking this court to reverse the trial court, remand it for a new, full, and complete diversion hearing and sentencing hearing.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the trial court's denial of judicial diversion because the trial court considered the applicable factors, weighed those factors, and explicitly put its ruling on the record, thus warranting this court's application of a presumption of reasonableness. Moreover, the trial court did not consider any inappropriate factors, nor did the trial court deny the defendant an opportunity to be heard.
Simpson, I briefly scanned the transcript of the sentencing hearing to see if the trial judge mentioned Parker or electroplating, and I didn't see that at all. Did she specifically address by name those cases?
No, Your Honor. The trial court did not explicitly say Parker or electroplating, nor did the court explicitly go line by line through those cases, but nor is the trial court required to do so. I
saw in your brief, and it may be where you're about to go, that courts don't have to use the magic words that are set out as factors. But, and again, I just scanned the transcript. I didn't see where she really addressed any factors. Can you point me or tell me what she did do on these factors?
Certainly, Your Honor. The first factor that the trial court focused on was the serious circumstances of the defendant's criminal conduct. On the record on pages 48 through 49, the trial court noted that sexual assault is offensive. And on page 57, the trial court noted that sexual assault is more serious than, for example, stealing somebody's tires. Sexual offenses are personal. The trial court also extensively focused on the impact of the defendant's criminal conduct on the victim. On page 48, the trial court noted that the defendant caused harm and a lot of problems for another individual. On page 67, the trial court noted that the defendant assaulted the victim in her place of employment. And the record supports this factual finding. In volume 3 on pages 7 and 8 in the state's recitation of facts, the defendant hugged and grabbed the victim's buttocks, kissed her left breast, and then moved his hands to the front part of her pants and attempted to put his hands inside her pants, all in her place of employment. After this offense, the victim underwent extensive therapy and took medication to assist in her mental health issues. That's reflected on page 37 of volume 3. Additionally, the defendant's criminal conduct negatively affected her employment and her marriage. She explained in her statement that she could no longer go to that particular apartment complex. She had to be transferred to a different location. Nor could she bear to be in her place of employment by herself. She always had to be around other people. She also commented that she had since married the individual who was her fiance at the time of the offense, and the effect of the defendant's criminal conduct caused great strain on her marriage, and she no longer felt comfortable fully engaging in that relationship like she did prior to this offense. So the trial...
for better or for worse, I think the state of the law in Tennessee on this issue is when a trial judge is looking at some type of judicial diversion, you focus more on the defendant than you do the victim. For better or for worse, that seems to be the state of the law when it comes to considering whether or not judicial diversion should be granted. Everything that you've talked about comes within, I believe, the circumstances of the offenses and certainly how that affected the victim, which unquestionably was negative. But what about Mr. Defendant's amenability to correction? The defendant's criminal record, the defendant's physical and mental history or health, the deterrence value, were any of those addressed by the trial court?
Yes, Your Honor. The trial court made specific findings about deterrence. The trial court stated that the sentence should serve as, quote, a deterrence for others in this community, that you just cannot go up and kiss somebody's breast because you feel like it. that clearly goes towards a factual finding of general deterrence.
But again, that's towards the public. As Judge Easter is asking, and I agree, whether it's for better or worse, that the focus is supposed to be on the defendant and his ability to be rehabilitated through diversion. And so, talking about his social history, his mental and physical condition, his drug use, if there is any, family responsibility, marriage stability, all those things are things that our Supreme Court has kept saying the trial court's supposed to be reviewing. And I have not looked at the transcript like Judge Easter has, but in looking at both of the briefs, it doesn't appear that the trial court mentioned any of those things. And then you add to it, my second concern is the law is clear. While they may not have to mention every factor, they have to put on the record what they considered and how they weighed it. And even reading your brief, it doesn't appear that the trial court put anywhere on the record, I'm weighing this factor in favor of diversion, I'm weighing this against the defendant in favor of incarceration. None of that, based on my reading of the briefs, appears to be there. So I'm with Judge Easter. The impact on the victim is horrible, and it is something that is taken into consideration as part of this and as part of his conviction. But diversion is about the defendant, and can we rehabilitate him? So let's dive into the defendant's life and his background. Can he be rehabilitated? What did she consider about the defendant specifically, and how did she weigh that versus the impact on the victim?
Your Honor, at the beginning of the ruling, the trial court noted that the defendant had apologized. Impliedly, that goes towards amenability to correction, showing remorse for the offenses. The trial court also noted that the defendant had a minor child, and the court was concerned that the defendant might possibly commit a sexual offense against his minor child or another minor. So going to partially specific deterrence as well as general deterrence, the trial court was concerned that...
Where did that come from? Where did that concern come from in this case? This victim was not a minor, was she?
No, Your Honor.
Then why would the judge inject into her findings concerns about the defendant committing some act against a minor?
Your Honor, that's unclear from the record, but the trial court was concerned that not having a conviction would, or having a conviction on his record would serve as a warning to the community. That can be found on page 57. And the defendant himself admits that the trial court specifically and strongly referenced deterrence value to the defendant. So clearly here, while the trial court may not have explicitly gone down the list of Parker and electroplating factors, the trial court impliedly considered all the factors and placed on the record the ones that were the most important and applicable to this case. And that is what is...
I got the impression, based on wording that the trial judge used, that she would not have granted judicial diversion in any sexual battery case.
No, Your Honor. During the trial court's ruling, defense counsel interjected and stated that the Tennessee legislature had, quote, has not per se said that sexual battery was ineligible for diversion. The trial court responded and said, I didn't say that. I think if you read the diversion statute is within the discretion of the judge. So clearly the trial court was aware and following the law that sexual battery is a divertible offense. And the trial court exercised her discretion, the discretion that she is given under our sentencing scheme to deny diversion in this case, based on the factors that she found to be most important, specifically the circumstances of the offense, the huge negative impact on the victim, and general deterrence. Thus, this court should apply the presumption of reasonableness because the trial court complied with Parker and electroplating, as well as King, our Supreme Court standards here. Also, to address the defendant's argument that the defendant was denied an opportunity to be heard, if the defendant is raising a standalone claim that he was denied due process, this court should waive that standalone claim because he is raising it for the first time on appeal. As far as the defendant's argument concerning the abuse of his argument that the trial court abused its discretion, the defendant misconstrues the record here. During the defendant's testimony, he rambled extensively about his religious beliefs, how he had good friends in America, how he loved America, the people, the law, the Constitution, how jail is like hell, how home sweet home is like in heaven. Extensive rambling, completely off topic. And at some point, the state objected to relevance. While he was describing how he was shot at and how he found a bullet hole in his car while he was delivering pizza to a gas station. At this point, the trial court explained that defense counsel should focus the defendant's testimony on relevant issues, such as whether the defendant did what was alleged in the guilty plea, whether the defendant was remorseful for his conduct, and whether the defendant would engage in criminal conduct in the future. The trial court did not abuse its discretion in doing this. The defendant's discussion was completely not tracking with the factors that the trial court was trying to learn about, the Parker and electroplating factors. So the trial court reasonably exercised its role as a gatekeeper to limit the defendant's extensive rambling at this point. As far as the...
let me ask you a question. So if we were to agree with the defendant that he wasn't given a full and fair hearing and the trial court didn't consider all the factors the way that she was supposed to consider them, and to Judge Witt's kind of question, seem to have a bias towards these types of crimes and granting diversion, would you agree that it's best if we send it back to a new judge?
It's the state's position that the trial court gave a full and fair hearing, but if this court concludes otherwise and decides that the record is incomplete, then yes, remand for a new hearing would be appropriate. That is definitely within this court's discretion to do so.
What about to a new judge?
Your Honor, the defendant did not make a motion to recuse the judge, which the defendant could have done so at any point during the hearing. Absent the defendant's argument that the trial court considered an inappropriate factor, which again is the state's position that that argument misconstrues the record, there's been no evidence of bias against this defendant, or that any evidence of the trial court cannot fulfill its duties under the law. So no, Your Honor, recusal is not warranted here.
Thank you.
There seemed to be a lot of stops and starts during this hearing. In fact, maybe just from, again, my skimming of the record, maybe even suspended one day and picked back up the next day. Is that right, Ms. Simpson? Is that what
Yes,
happened?
Your Honor. After the trial court issued its ruling, the defendant asked to reset the hearing to speak with the defendant and to speak with the state. When the session reconvened the next day, the trial court reiterated its ruling, and at that point, defense counsel attempted to introduce additional proof, even though the trial court had issued its ruling. So as far as that falls under the defendant's argument that he did not receive a full and fair hearing, the defendant had ample opportunity to introduce any proof, any medical records, and the defendant failed to do so during the hearing when presentation of proof was appropriate. Only after the trial court ruled and imposed a sentence of partial confinement did the defendant start protesting and come up with other reasons to try and convince the trial court to change its mind. It is fully within the discretion of the trial court to close proof, and the defendants had opportunity to present his proof. Both sides argued, and the trial court issued its ruling, and only after that point did the defendant apparently disagree with the ruling and seek to interject other issues into the ruling. So clearly the trial court gave the defendant every opportunity. And defense counsel even admitted that he did not have the proof ready to go during the hearing on the first day, when the trial court could have appropriately considered it. And unless this court has any other questions, the state would respectfully ask this court to affirm the trial court's decision to deny diversion in this case. Thank you.
Thank you. Rebuttal.
Sir, Your Honors. Thank you. Just to address a few of the points made by Ms. Simpson, opposing counsel, Your Honors. Direct the court's attention to the record. I think Ms. Simpson was citing in this area. The question was asked. I know Mr. Mehdi at some point was talking about his history. As we know, as this court may be familiar, sometimes witnesses will go off astray a little bit, and it's the counsel's job and the court's job sometimes to bring them back. But in this instance, that was not what transpired. What transpired is the court said, these are the court's words. Let me give you a little guidance. All I need to know is if he, in fact, did what is alleged in the guilty plea that he did. If he did, I want to know what he did. Okay. Sure, I understand. It's and I mean, as an aside, Your Honor, and I think this is not, there may be case law on this issue. I think there is. It is a very difficult position for trial counsel to get into a debate with a trial court over objecting to judge. It is much easier for counsel to object to something that has been done by opposing counsel, but it's a very awkward predicament to be in, and I will tell the court as trial counsel to object to a judge. The court set the parameters there, and counsel stated, defense counsel, myself, sure, I understand. And if he did do it, this is a trial court, then is he remorseful in any way whatsoever? Yes, Your Honor. And that he will not do it again, and then turn it over to the state. It's real simple, okay? What you have there, Your Honor, is the dictate by the court. Let's just not go on and talk about all this other stuff that's in parking and electroplating and in TTA. Here's what I want to hear. Problem is the case law is clear. Even King came recently, but King is still talking about parking and electroplating, that those things are still relevant. King only really deals with the presumption and how the court's going to analyze when there's a deviation there. But and these are the court's words. And these are my words in front of trial court when that happens. And this is tantamount, I would consider to a respectful. Maybe I could have been a little more forceful. It's tantamount to an objection. I just wanted to give Your Honor a little bit of background. I don't need all that. In so many words, I don't need all that Parker and electroplating and the statute. Here's what I need to hear. We're going to streamline this. Later, the court talks about we'll be here all day. Well, sometimes justice takes a little while. And if there's an objection that's appropriate, the state jumps up and objects. Judge, that's not relevant. 401, 403 is not relevant. That's the proper mechanism. It's not for the court to say, I'm going to narrow it down in my court or else we'll be here for this afternoon. I want to get done. That's not the test. That's not consistent with the case law that this court has repeatedly said. You've got to apply this analysis. And the magic words, Judge Easter, as you indicate, the magic words are not required. But at least the court needs to see that the court did engage in what has been set forth by this court repeatedly and what's been set forth by the legislature. That did not happen here. Let me just deal with this issue concerning the balancing. This court is correct in some of the questions that have been asked. The balance here, and this is directly from the record here, page 56. The reason why he was not placed on diversion, it is that, and these are the court's words, is that I do feel that people who do things like that, she's referring to sex offenders. Legislature said there's only certain kinds of sex offenses that we're not going to make eligible for diversion. This gentleman, as the state has conceded, is eligible for diversion. Especially the fact that he has a child. I don't ever want to be in a situation I hear something happen to his daughter as a result. There's no indication about any improprieties with his daughter. He didn't lose custody because he abused his daughter. Nothing of the record. So this is just, in my opinion, respectfully, speculation. That's a very personal thing in terms of touching, sexually arousing, raping. He's not charged with rape. All those things. That is in a whole different category. That is not stealing somebody's tires. What the court is doing there is basically saying, hey, look, I don't have a theft of property. This is not an easy one for me, counsel. And I just find it hard to grant diversion in these kind of cases. And it was pretty clear. So the balancing, it appeared the focus left from Mr. Mehdi early on in terms of how the court limited. But after the victim testified, and I'll remind you of this, and I'll leave the court with this. The victim described it. I'm not minimizing. I think this court has already acknowledged the testimony record. We're not minimizing that this was traumatic for this young lady. But even looking at the circumstances of the offense, where the court appropriately considered can look at that. The circumstance of the offense indicates that the victim even acknowledged that she had come over to Mr. Mehdi, put her hand on him, and was consoling him because he missed his relatives, his wife, who was living in Texas. So regardless of whether this is deplorable, reprehensible conduct, whether he should have asked first or not even engaged in the conduct, that's a separate analysis. But it does go into the context of how this occurred. Did he have the wrong idea? Perhaps that's a strong argument to be made by the state. But the court still has to follow the law, still has to use the appropriate factors, and not to state a blanket presumption there in terms of these kind of offenses. With that, Your Honor, we'd ask this court to reverse the ruling of the trial court respectfully, to afford Mr. Mehdi a full, complete hearing where all the factors are considered, to appropriately consider those factors, and then make a judgment accordingly. And we respectfully ask that the matter be reversed.
All right. Thank you.
Thank you.
Court appreciates the arguments we've heard today on this case. Excuse me. And that completes the argument in this case today.
Thank you, Your Honor.
This Honorable Court of Tennessee is now in recess.